Welcome to Divorce Cafe, the podcast where we demystify, detangle and hopefully detox the legal processes that follow a separation. We are relationship property lawyers ourselves, and this podcast is about upskilling everybody, lawyers and people going through a separation, to remove some of the conflict that happens after a separation. Occupation rent is an area of relationship property law that is just not very well understood. It involves maths, but it's not just that. Occupation rent is a bill that one party might send the other when the family home finally gets sold, but it's not even mentioned in the Act. It could do with some demystifying, which is where today's guest comes in. 25 years a family court lawyer. She is a director at Central City law firm Haigh Lyon, a straight talker, formidable advocate, a little bit scary, but seems like a lot of fun, and obviously mathematically gifted, because just like our Shelley here, she is a big lover of Excel spreadsheets. It is her love of spreadsheets that drew us to her for the topic of occupation rent and post-separation adjustments. Amanda Donovan, welcome to Divorce Cafe.
Thank you very much. What a lovely entry that was.
Yeah, well, thank you for having us here at your offices. Very beautiful, down in central Auckland. So, Shelley's got the icebreaker today.
Okay, so your icebreaker today. So your biography on your website says, on the inside, she is the firm's go-to for solving problems. Her intuition is her superpower. So can you give us an example of when intuition has served you well?
Oh, we all have those. I quite like that part of the end of the website blurbs, otherwise known as your spidey senses, right? Yeah. That you do know. I think this comes from being able to empathise with people and to really sort of understand what it is you're actually trying to do here. Because eventually we all know the law and everybody can understand what it is the legislation says, more or less what you're supposed to be interpreting to help people through that part of the process. The more difficult part sometimes is trying to help your client understand the other client's perspective. Because if you can help someone understand somebody else's perspective, and sometimes you need to intuitively be able to work out what it is, because the issue is not the issue, we all know that, then that's the sort of thing I'm thinking of when I talk about intuition. Yeah. Sitting in a room at a round table meeting, something's not quite right, and you're looking over there and you think, hang on a minute, and then you sort of say, so what's important to you with respect to this? And then they go blah, 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 blah. And you're like, okay, that was it. Yeah, so you're sensing something. So it's that sort of thing that I was thinking about when I...
So it's not really one example, it's every time that you use your intuition, I think. It's probably the case.
As a supplementary, the psychology question, let's put that one in now.
Okay, so we're this was question number 12, but we're going to segue into it now. How is a background in psychology a useful thing for a lawyer?
Sure, okay. And this comes up with a lot of clients often, actually. They look at the website and they're like, oh, you know, I am not a practicing psychologist, so let's be really clear about that. But I do keep up with the studies and I do keep up with things just to understand where the research has gone, because some of that sort of defunct research from 20 years ago that we've moved on now. But again, you know, all of that is helping to understand somebody else's perspective. But the biggest part I think that comes out the most when you meet people is that some people turn up and lots of lawyers say, look, it's irrelevant why you separated. It's irrelevant, we need to get on to the division. And I think, and this is why I think maybe it's psychology related, is that it is relevant. Because if I learn that you separated from your husband 3 months ago, but you were thinking about it for 2 years prior, and I dovetail that in with the grief cycle, that when that wife started thinking about separating 2 years ago, she started on her journey around that wheel. And by the time she made the decision to separate, she probably reconciled herself that we're at separation right, and now I'm ready to get on and do the things that we need to do with lawyers.
She'd done her grieving.
100%. But if you're the husband who finds that out by surprise 3 or 6 months ago, and you start to think about where they are on the grief cycle, then you're potentially trying to negotiate with angry, or somebody who hasn't got anywhere near their acceptance yet. And if that's the case, then it's very difficult. Because people always say to me, you know, if it's so straightforward, because I always say, identify, classify, value, divide. So straightforward. Why does it take 3 years and cost $100,000, on those really extreme cases? And it's often that. Because if you get anyone even to a room for mediation and you're trying to negotiate rational with angry, it's very hard to do.
Or rational with haven't been heard yet.
All of that.
Or
upset,
raw, or sad, or betrayed, Can you just say those 4 things that you quickly...
Oh, the legal
Identify.
part?
Yeah.
Well, straight out of the
classify.
PRA, in my mind, and how I always explain it to our juniors, is that, and that flows through to your Excel spreadsheet, is that we're identifying 4 easy steps in a relationship property case.
It's easy.
4 easy, super basic, and all my clients sort of chuckle at me in our first meeting, and I write them down. Identify all your assets and liabilities. And I say, that's easy.
Yeah.
Most of the time, unless someone's hiding stuff. You know what they are, write them all down. Secondly, look at them all, and then we're going to classify them as either relationship property, something you're probably going to divide equally, or separate property, something that's not, inheritance or the like. Then we're going to value them, then we're going to divide them. And then I put my hands up always, and I sort of say, and then, say you got $1 million each, 500 each, and then we have to say, hang on a minute, does that seem fair? Because you've got a salary of 200,000, I've got a salary of 0. That's great, but if I take my 200,000 down to the bank husband, they'll say, great deposit, great serviceability, you're in, and you'll take your 500,000 down, and they'll say, great deposit, no serviceability, you're out. There's an economic disparity there between you, and then I go through those adjustments, which ties us probably quite nicely into this. Your Section 15 type adjustments, has there been an economic disparity? And then as at the date of separation, and then from that date through to the date you settle, are there any other adjustments that need to...
Is there something that needs to happen to even things up or make it fair as between separation, the time that you separate, and when you're actually getting to the end of your 4-stage list. So that does bring us...
So that's perfect. So today we are talking about occupation rent, and so that we're all up to speed. Amanda, can you tell us what is occupation rent?
Well, it's as clear as mud to start with, so I understand why it's a tricky topic for people. But where it came from was sort of a equitable accounting type situation. So in equity, before it was codified badly, perhaps, is what does it look like and what's equitable between these two people post-separation. And so then from there, we have our Section 18B of the Property Relationships Act, which sets out that from the date of separation to the date that you settle all of your matters, you can make some of those equitable adjustments between you as to what's necessary based on contributions to the relationship. So, and that's sort of the key.
And that's contribution after, isn't it? That's
yes, from the date of separation.
And sometimes, we'll get on to that. Sometimes nothing is necessary to balance those up, and sometimes there needs to be some moving around of money so that it's just between the parties, right?
Yes.
What happens after separation.
Yes.
So the legal basis for it then is 18B.
That's right.
Yeah. So occupation rent it ended up as one of the ways that judges could work out how to do that equitable accounting. I love that.
Yes. Yes.
But, and so when, to go completely back to basics, what is it and when does it apply? So when one person continues to live in the house.
Yeah. So it used to be, if you sort of look at those equitable things, if someone had been ousted from the house, using the old money language with respect to that, then the other party would give notice that they seek occupational rent, and there would be some adjustments in the equitable accounting later. I think what happens now is that at the start, the conversation's too hard. And that really needs to be reined back in, because if the situation is not clear to both parties at the start as to you're going to be responsible for this and have this benefit, I'm going to be responsible for this and not have that benefit, whatever that might be, then you are never going to be able to get to that equitable accounting, because neither will think it's equitable. Why should I pay you this when you didn't tell me?
Yeah.
If you'd told me, I wouldn't have stayed in the house. I would have gone and lived somewhere else that I could afford, and that's where it all becomes unjust.
Yeah. And the reason they call it, I think what you were getting at, the reason they call it occupation rent is, so the one person, home is an asset, but it also is an asset that has benefits coming from it. One is the benefit of living there, another one is the benefit of getting a rent or an income from it. So the person who stays is...
Oh, there's three. The third is the benefit of using the other person's capital, you know, for a period of time, because if that didn't happen and they could release their capital, they could go and do their own thing.
So when one person sits in the home for a number of years, the other person doesn't have their capital out of the home, and so that can create some inequity. So this person's getting the benefit of that person's share, as well as the benefit of living there or rent. And so the 18B comes in to try and say, well, how do we make it fair for this person who had to go and rent somewhere else?
Who's having to go and rent somewhere else, so they're having to pay money to rent somewhere else.
Yeah. So what problem is occupation rent trying to solve is our next question.
Well, it's trying to create an element of fairness and what's just, as you said, with respect to those contributions to the marriage or the relationship. And you're trying to equalise those or offset them. And the thing that we see them get offset against the most is spousal maintenance. So there's really two sort of scenarios here. Well, there's a few, but there's often a mother and children that maybe are staying in the house because she doesn't have an income. Children are young, or she hasn't been working. And so in those circumstances, if there was an occupational rent charge to her, it's going to turn up in a spousal maintenance claim. So if the husband says, well, I want to charge you $500 a week by way of occupational rent, she says, sure, no problem. Here's my spousal maintenance budget to pay for that.
If it's raised at the time, right? He says, don't you worry, I'm going to do the right thing by you guys. You and the kids stay in the house. I'll keep paying the mortgage, or you stay there. And he doesn't say, or he maybe doesn't even know, isn't aware that when he goes to see a lawyer a couple of years down the track, they'll say, well, you're entitled to something on account of your capital being left in and you paying rent elsewhere. So if that had been said at the time, then the wife could have said, well, now I'm going to need spousal maintenance to pay for that. If it's not discussed at the time, the wife doesn't even know that maybe she should be applying for spousal maintenance, right?
And the courts have been quite big on notice. You know, if there hasn't been notice from one party to the other of a claim for occupational rent, they're not so agreeable to granting the occupational rent.
Notice in the early days.
Yes.
It's an indication, which,
And then you get the aggressive notice, which is on day 3 of separation. I will be claiming occupational rent from you, which sort of flies over the top of everybody, but later will come back. So that's why I think everyone just needs to be really clear as to what that looks like. There's always a lot of stress around this, because you go straight away, for the average home, you go straight away of having a disposable income of $X, which goes this far, and now you need to make it go this far. And that's just stressful. And so nobody wants to deal with it. One person thinks it's, both people consider it incredibly unjust, because I'm not getting enough and I'm paying too much. How am I supposed to set myself up over here when you've got everything there? And so that's the earliest conflict I think that we see, is with respect to agreements around occupational rent.
So talk to your lawyer early, I guess, straight away, before you set up that arrangement, so that you're both on the same page.
That's right.
To break it down, what you're talking about is that in your scenario, the husband with the salary is charging her occupation rent, And then she says, well, you need to pay that as spousal maintenance. That's what you mean when you talk about spousal maintenance. So it just basically cancels each other out, right?
Yeah.
Because he was meant to pay for it. So that's what you're talking about when you're talking about offsetting it against spousal maintenance.
That's the discussion, but there can be quite a fight about it, right? Because if she didn't claim spousal maintenance, and that's where so another thing that can offset occupation rent, right, is other kinds of contributions. So you were mentioning Section 18B is meant to be making things fair or just as between the parties in respect to contributions that they've made after separation. And their contributions are the exact same contributions, the same definition as in the Act, right? So you've got financial contributions, you've got care of children, foregoing a better standard of living, use of capital, those kind of things. So if there are cases where one party's been in there for an extended period of time, but they've been caring for the children pretty much 100%. And at the end of the day, the court has said, okay, yes, there's half of the net rental back maybe. So half of the profit that you might have gotten if both of you'd moved out goes back in occupation rent to the other party. But then there's an offset of X amount for the contributions that you made to the children, which is part of why it gets so
and spousal
complicated,
maintenance.
Right?
And when it's that scenario, I say you're using spousal maintenance as a shield. So because when you get hit with the occupational rent claim, you're shielding yourself by pushing back with the spousal maintenance claim to offset that when you have one income that's not earning money.
Yeah.
If you've got spouses where say this time the husband stays in occupation and is the higher earner and the other one's earning but maybe not to the same capacity or they're similar, what I quite like to do, and remind me to come back to the wife scenario at home with the children again, but what I quite like to do is get a rental appraisal. Or if they don't want to spend money on a valuer, then just 3 appraisals and we'll take a midpoint. And then I say to the person in occupation, right, you pay that into the joint account. So that's, you are paying rent, and then anything above that, then you divide that equally. Because then they are meeting what would be the standard rental payment. Often it's a little bit discounted because you're in the house and you'll look after it better than a tenant would. But it gives you then a very clean parameter as to how to...
So then you take the outgoings from that account.
Yes.
Yeah.
And if there's a shortfall, you both have to top up that account.
Right. And if the person who's expected to pay the rent can't afford it, then you talk about it then. Okay, so, and that's when you could say, okay, well, I'll pay half and you pay half.
Yeah.
And that will be spousal maintenance. It's not going to be an extra. You're not going to owe it back to me.
Yeah. And you're just thinking about that because the rent that they're paying that's going in, of course, it's if you're paying $1,000 a week, and there was no mortgage, well, 500 that's yours as well, and 500 of it's theirs. So that's
where they have it.
Yeah, that's right.
Yeah.
Okay, so next question: how does it work? How does occupation rent work?
So a bit like what we were just describing, and I think sort of 2 parts. So maybe it works in what you're trying to do is give notice early, reach agreement early as to what that would look like, so that by the time you get to that division, you've got some easy accounting on who owes who what. And what often happens is just before we've reached an agreement, and then bang, in comes this, I got the pool fixed and the pump fixed and this done and all the rest of it. And the list starts to grow and that creates tension, then there's no agreement. So I think for clients, either themselves or we do it, we just keep an Excel spreadsheet. In fact, it's in our big spreadsheet that has adjustments. So if you're the client, if you're the spouse and you need to get the pool pump fixed and it's going to cost money and you're going to want half back, get it approved. Say, pool pump's blowing, I've had a few quotes, this is, which one do you agree to? And, can we pay half? I don't mind paying it now if we can adjust later. Off you go. So that you're keeping a schedule of those. Because nobody, even in an intact relationship, you wouldn't like to be sprung with a big bill that you didn't know about. It's like, why haven't we talked about this? So it's only worse when finances are tight and it's on separation. And get consent, because if one party ends up keeping the house and you've gone and fixed all the light fittings and done a whole lot of things that weren't agreed, the other party will say, well, you always knew you wanted to keep the house and now you've just got a really nice house and I've paid for all of those things to be done. So many touch points of conflict. So keep a spreadsheet on all of those things. And then how, going back to the maybe the mother with the children in the home, there is a arrangement that's not passed through legislation yet. In fact, it's a way away, which is, what did we say, financial income sharing arrangement. Family income sharing arrangement, FISA. And now I still use that. So if you listening to this podcast are a husband or wife and you think, what's the cleanest way to do this actually? You know, we're not super tight on money, but we would like to find a fair way. What this arrangement suggests is that if you earn 40,000, your husband earns 100,000, that you just keep pooling that. And that you both agree, no big expenses, nothing outrageous, you just keep going with everything, income sharing for a period of time until you can get on. And the legislation itself strictly says that your income post-separation is your separate property. So it's allowing an arrangement that's outside the Act, but it's actually very fair to both parties until if you want something that's not messy and super clean
and it avoids
fair.
Spousal maintenance concerns, and I think it's also in substitution for a Section 15 adjustment, right? So
if you're income sharing,
yeah,
that becomes a whole
that's
different
the new
podcast almost. But yes, because
that was the intent
yes, that's the intent behind the Act, but we're not quite there. So,
Only because it doesn't take 2 years. Takes more than 2 years to raise your income earning potential.
Yes.
Compared to
It's
10
FISA 5 years though?
Is it?
It was 5, for a long relationship,
Yeah.
which they were clocking at 7 to 10 years. So it was
I know,
considered
it's
a long
amazing what's
relationship.
a long-term relationship now.
Yeah.
What is the biggest misconception about occupation rent?
How to treat interest payments and principal payments, I think is the most tricky one, because I feel like that's wrong all the time. So quite often when money's tight, we advise people to see if you can drop it down onto interest only anyway, because that creates a little bit more cash flow. Same with KiwiSaver. If you're on a 6 or 4 or 8% KiwiSaver, drop it down to 3%. I know it's your separate property income, but it does allow a bit more cash flow to let everybody get on with things. And I always ask to see where the KiwiSaver's at, because they say, my income's only this, but you're putting 8% in over there, which is reducing your available funds. Anyway, back to principal and interest.
It's a life hack, isn't it?
Principal and interest and principal payments. Principal payments, if your mortgage is 100,000 and you've got a spouse that's paid off 50,000 of that over the period of time, then they both benefit from the principal reduction, and that person gets the principal repayments that they paid back in full, and the interest payments are halved. So the which part gets halved and which part doesn't
This is
get
after
halved
the relationship ends.
when you're
right?
doing the full division.
I'm talking about during
so
the
you've got-
relationship, if they've paid 50 grand.
After the relationship.
ends.
Your occupational rent type payments. And then
So you've got occupational rent, and then on the other side you've got the shareable outgoings like insurance rates and interest on the mortgage. And then you've got the capital, which is actually increasing the equity.
yes,
And stuff.
and they all need to be thought about separately. So if you go back to the scenario where the husband's in the house and they've got a similar income or something like that, and he's paying rent, I've effectively asked the couple to put 2 hats on. One is the landlords. You're both the landlords, you're responsible for the mortgage, the rates and the insurance. And he's the tenant, and he pays rent and is responsible for all of his utilities, water, whatever, Netflix, etc. And so there and clients, if you put the 2 hats on them, they go, oh, okay, I get that now. And that's where he's paying rent. Now, if he's not paying rent, maybe the agreement is, actually you just pay the mortgage. And so then you need to be really clear as the landlords, you are paying occupational rent, but you're doing it by way of paying the mortgage. That's, you're meeting your half share and her half share each week. So then what if it's just the mortgage, we've still got a couple of other things here as the landlord. We've got the rates and the insurance, because sometimes people just bowl it all in together, mortgage, rates, insurance, and that actually starts to become a bit punitive, perhaps, depending on how big their loan facility is and whatnot. Or maybe it's not quite enough.
You mean if one person stays in and they take on all the outgoings? If they say, okay, you're in the house, because that general rule people talk about is if you're in the house, you're paying the outgoings. But you're right that once you lump those all in together, sometimes that's a negative number, isn't it? The rent and all those outgoings.
Yeah, that might be too much. So are you actually paying a rent? So you take out of your pay, put it in there, and then the landlords use that how they see fit and top it up as they need to equally. Or are you just taking over the mortgage payments and that's your occupational rent? Or is it mortgage, rates and insurance, and that's your occupational rent? And just sort of be clear about all the different things. Mortgage, rates, insurance. With mortgage, two-part, principal and interest, how we're going to treat those. And then, things that need to happen on the house. While you are doing that, if it's what we all face that's most difficult, is you've got a mum with the kids in the house and maybe an ex-spouse who's aggrieved in some way and just says, well, I don't want to pay you anything. So that's when
I've already supported you.
Whatever that looks like, and then you're looking at your sort of spousal maintenance applications. And if they're not paying the mortgage, then your spousal maintenance application needs to encapsulate everything that you need to keep that house running. And if the funds from all sources were available to the husband, that's going to be a successful application for them. So that's why I think, there are options there, but that one, and spousal maintenance applications are awful because they're still, costing a spouse money to try and achieve, an outcome that is just, which is where we're trying to get to.
It's difficult when you're already getting half of what you thought you had anyway. We've probably already covered it. How do you go about calculating it and giving us a few worked examples? I guess you've given us examples of how you can structure it at the beginning so that it's neat and tidy with paying rent. What about calculating it at the end?
So I just run a spreadsheet.
When both parties are continuing to pay the mortgage 50-50. So that's a common one because it's so expensive in Auckland to handle the mortgage on your own. One party stays in the home, but they're both sharing the mortgage and the other party's renting. How would you go about calculating that?
So I still come back to if both parties exited the property and you could get a rental amount for that property, what would that look like? And if it's $X, then that's your, take your 3 appraisals and take the average, and that's your occupational rent claim. All else being equal, that's your occupational rent claim. Why it's very important to give notice of that early, coming back to what I said earlier, is that they need the opportunity to say, well, actually, I can't afford that. I don't want to do that. Off you go. Now, if you don't give notice of that,
rent, I'll go pay half market
absolutely.
Rent, smaller.
And as a lawyer, especially junior lawyers, when you're drafting your application, we say, and I think it was, Usha Patel and Judge Adams, as he was then, who ran a junior family lawyers course, they still do it. When I did it 25 years ago, and they said, the difference between the A lawyer and the B lawyer is that the A lawyer will always go back to the legislation and have a look. So when you're drafting those applications and they throw in with everything else, section 15, 18B, think about 18B at that point. Say, if I'm going to file submissions in a year and I'm going to be claiming something here, then what do I need that to look like now? What sort of things do I need to be doing? And this particular thing I think is a trick for young players because it's not in the Act. Right, if you're reading 18B, it's not actually saying, make sure you give notice of occupational rent or something of the like.
And occupational rent isn't even automatic. It's not, it's
discretionary.
not a right.
It's discretionary.
And it has to be fair in all of the circumstances. Do you think that takes us into too much of a grey area? So our law, foreign, overseas lawyers say, you're so lucky you've got a lot of clarity in your Act, which is kind of a surprise. Some people work in it. But do you think that occupation rent and Section 18B should be more codified? or that occupation rent should be brought in, should be codified in the Act to make that.
Yeah, I think it would be
Clear
much
and
easier,
mandatory.
obviously,
Yeah.
if everybody was running to the same rule book or playbook, and when, there's a general practice. But even if it was codified, often we don't see the clients until lots of that time has passed already. And then the lawyers roll in and you're making that claim, you can, but you still need to do that, especially if you're filing court proceedings. And if you haven't yet, you need to, but the letter shouldn't be, my client claims occupation rent, it should be, your client's been in occupation and that's been fine, now need an opportunity to be able to claim occupational rent. If they don't think that they're going to be able to sustain this, then we need to look at,
And there are other ways, I think
options.
we're getting to other ways. So are there any general principles that you can point to with occupation, like broad? We've already talked about how it's not actually set out in Section 18B. So what are the general principles? For example, you hear about a grace period.
Oh, I see, yeah.
Yeah. Is there anything like that?
So the grace period did exist sort of for a period of time to allow everybody to settle into their new circumstances, but I think it really is quite fact specific. Because if you have, and it really just depends on disposable income, because if you have somebody that's in the house and all of a sudden everyone was already using their disposable income pretty much every week, and now you have to create a new home for that, and there's no extended family to stay with or whatnot, even that's temporary.
And it's reflected in the cases, isn't it? So that if the other parties had to start paying rent straight away and they don't have other forms of income or that some separate income like a business, so they are suffering, you're more likely to have an occupation rent, successful occupation rent claim later. Whereas because it's not automatic, in other circumstances where the person goes and rents or lives with mum or isn't quite so hard up, they might say, well, it's not actually just to provide an adjustment here or a smaller adjustment, not half of the market rent after outgoings. So
You do get that.
We
The other one that I see quite a lot is where there's not enough. If they have some sort of revolving credit facility, then one party starts to use the revolving credit facility to pay rent and their expenses
and that becomes
outside of
joint
the home. Well,
debt.
more often than not, no one talks about it.
Yeah.
I see. And so then you turn up and say, oh, yes, but they've had $85,000 off the revolving credit facility. So when we do the division of the home, that needs to come off their side of the ledger. And then they say, well, I'm claiming occupational rent from you. And I say, well, then I'm claiming spousal maintenance. And you end up in the situation that we're trying to avoid just because it's easier to carry on that way.
And
so
not
then you
talk
say,
about
do
it.
those costs, if they're reasonable, are they actually just shared? You had occupation and you had this, but
Like pooling expenses, that example.
Yes.
Like keeping pooling
the
incomes.
FISA type arrangement, yes. So again, it's communication early on, because if the agreement is you can use that account for rent and your utilities or whatever's reasonable, then great, so be it, but it will come off.
And there was a case where the wife actually stayed in the family home for 20 years. She had 9 children, or there were 9 children of the relationship. And at the end of the day, the occupation rent she had to pay to him was very low. It wasn't the outgoings off market rent paying him half. It was it was lower than that. And the judge said part of that was that they'd agreed that she could stay in the home until the youngest was 18. If she paid the outgoings. And the mortgage was quite low, so the outgoings weren't massive. But there wasn't able to be a retrospective claim for occupation rent there because they had talked about enough of the terms to be like, this is their arrangement, even with a 20-year.
And it wouldn't seem fair to charge someone 20 years.
Yes,
Well,
you've,
no, but that's
you've capitulated, haven't you?
that's right.
Yeah,
Because she didn't know. She wouldn't have done that.
That's the
if she'd-
claims that come in. Because if you look at it from the other side, the poor person who moves out, they
Yes.
don't have the benefit of their, say, $300,000 half share in the home, and they're paying rent elsewhere, and they're paying maybe child support or whatever else they're paying. So, sometimes there is need. But the bit, it's not enough that one party made a contribution. It's not enough that someone left their money in. It has to be just in all the circumstances that an order is made. And I think that is one of the things that'd be Yeah.
I wonder if that
Needs to
case
be
was
out,
around at the same time, sort of Section 26, although this was just contributions, wasn't it? Wasn't the division itself?
Yeah.
Because allowing her to live in the home.
Separation contributions, yeah.
Okay.
Yes, okay. So, contributions are very broadly defined in the Act, but occupation rent only takes into account financial contributions, the use of the capital. If the traditional division of roles has continued since separation, how does 18B deal with non-financial contributions?
Well, you're looking at Section 18 to see what, for the legal people who want to know where to go. Is it a contribution, and what does it look like? So the non-financial contributions, whilst you don't say, $100,000 equals this much, 2 children and 3 days a week at home or something like that. There's no calculation per se. It all comes back to what's equitable and just again. And I suppose the one area where some of the cases were going quite well in supporting women who have been out of the workforce with children at home. And then there's a couple that sort of took us a bit backwards again by saying things like, well, actually, this shouldn't be factored into Section 18B. There's non-financial contributions as an offset here.
That's what child support's for?
Well, no, that's what Section 15's for, is that actually you get your award in Section 15. So it's not a contribution to the relationship, which is sort of flies against the face of what we've been thinking.
Well,
it's a contribution.
Yes,
yes, sort of putting one M or, all the sections together, you would think that. But I think you can ignore that mostly and simply say that if there are young children, those contributions will be valued as equally as the financial contributions.
And in a few of the cases they did quantify it. One of them was like $15,000 a year per child was how they quantified it, and that was child support was neutral, so they took that out. But they quantified, I think in that case the person had much more of the care or all of the care of the children. So they did put a financial figure on it, and then they offset it to come up with the adjustment that was due to the other party. So again, what's just in all the circumstances.
So fact
there are lots
specific,
of ways
aren't
of doing
they?
it. And I think we skipped the question. When would you use interest on capital rather than occupation rent? So can you just tell us what interest on capital, what that means?
Yes, you're tying up my use of the capital, and I should get some sort of interest, some return on that. I haven't pleaded that in any cases, because lots of the decisions that what I'm usually relying on is capital gain. Now that's not always the case, especially at the moment. I mean, the last 2 contracting out agreements I've drafted, it's the first time I've put negative equity clauses back in since 2002, I think.
Yeah,
so
that's true. If there's a loss, the parties
in
will share the
Auckland,
loss equally.
yes, or in respect to their initial contributions or whatever, so whatever that looks like for those particular spouses. So there have been interest payments on funds that should have been paid that haven't. I've claimed that. So you're supposed to have paid $X, you haven't paid it, I've paid it, you've had the use of my funds to pay that, so I want that amount. Or on spousal maintenance due that hasn't been paid, interest on spousal maintenance amounts. But with respect to
the equity on the home.
No. If occupational rent's been claimed, I haven't claimed interest, and usually I claim occupational rent.
We've had one case, Stuart at our office, who when he was successful in claiming interest on capital, so an amount for the money that she had the use of, and some occupation rent, because that's what all of these tools, they're just ways that the judges will grab onto to say, well, this is a way of making this fair. This seems about right.
Actually, now you say that, we have just done that, but not Ben Jefferson of our office has, and I had an interesting case, and he was running it, whereby the couple separated 20-something years ago, and the boy stayed with the son. The wife went on to have another relationship, and then that ended. There was a settlement agreement, they had a dissolution, etc. A long time. And she's just come back and said, oh, I now want my half share of the family home. He had paid all of the mortgage. He'd been in it for occupation and brought up their son, so many things to take into consideration.
Need a spreadsheet for that one.
Well, where they got to in the end so far as settlement is say your use of capital will apply an interest component to it, and you can have that plus the interest component, not occupational rent for 20 years.
Yeah.
Because that would become, if you go back to your equitable...
There'd be no equity left in your side.
And she's seen lawyers along the way, so, again, that's
it's
sort of
misunderstood, I think, occupation rent. Yeah, I'm just looking for the quote here in terms of Griffiths, which alternative course is taken to remedy whatever the unfairness is essentially a matter of judicial discretion. So really the judge is looking at it, and there was the quote that I was actually looking for is the judge said something like, I refuse to be bound by any more arithmetical accuracy than that, or something like that, because that's what they're saying. They're standing back and saying,
broad
okay,
brush.
well, I'm going to balance up this, and that's why the sending a bill at the end saying, and that'll be $24,000 in occupation rent is not the end of the story. All right, we should crack on to the next one.
You were going to do the top one.
I think we maybe have talked about this. Is it fair to retrospectively put a rent on an occupation right when that rent was never really discussed?
No.
Yeah. So how do you deal with that by talking about it early, right?
Yeah.
Yeah.
Okay. So
I mean, it's not fair to not have it as well if the circumstances allow. So, but and if you are involved with lawyers, just get that conversation going quickly. I've just done a spreadsheet for a client actually, because I think where things become tricky sometimes is if we have a lot of clients who are self-employed or have their own company. And what they tend to do is they don't have an employment agreement for themselves saying you're a director of the company and you get paid $100,000 per annum, and then all the rest should be declared in dividends, and that's your profit, and that goes to the shareholders. What actually happens is they just have a card and they pay for everything all year, for everything. And then you have a scenario whereby the accountants just flush out anything personal, and that becomes drawings, dollars X. So then when you're saying, right, we want you to pay occupational rent or spousal maintenance, they say, well, that's not my actual income, but you don't have an actual income. So quite early on, I like to try and get somebody to sign themselves a market income so that we're very clear, both for economic disparity and for income sharing, what's income and then what's your sort of super profits, or what's, where are the dividends coming from with respect to the value of the with respect to the shares.
And that is really important, because was it the Iguazu case where they said if you've been working in a relationship property company after separation but you haven't been paying yourself a fair salary, actually I think Iguazu was about the fact that it went downhill. There was another one. You haven't been paying yourself a fair salary at the time, maybe you're leaving money in or whatever, you can't claim that back retrospectively, because you could have paid yourself then, you didn't. So that thing it's good for the person who's working in the company as well as... To
sort of be clear on what those buckets are, your salary. So then if you do have your salary, and get everyone's IR3s, because then you're seeing what their income is from all sources. The last 5 years, people say, I can't afford it. I have your IR3s, please. You're the detective, you're the lawyer, chip away. Well, just to see if there's anything left in the business. But with respect to income then, I say, right, look at the bank statements. This amount has been coming in sort of every fortnight. Let's put that in and just share it all. And then even at the end, the same, maybe this is more of your global division. Say you both want to buy $1 million house, but the wife's getting $800,000 in the division and he gets $200,000. He's going to need an $800,000 mortgage. You're going to need a $200,000 mortgage. So then what do those expenses look like if we make everything equal between you? What's the surplus? And then you start to get a better idea, his income, her income, and all their equal. Like there's no sort of savings in there and lavish holidays or cleaners. It's just your basics. And
where
then what's
does your clean break come into that?
Well, that is their clean break. So that's on their division when you're maybe trying to assess going forward and say, well, that's the division, but then you might have a wife that says, I want spousal maintenance of $1,500 a week. I can't afford $1,500 a week. And they say, well, then what about the, but you start negotiating on that. But if you can start to look at actually what's left if we make you neutral based on what you'll get and what you'll get, then you get to sort of quite a fair result. Another spreadsheet.
What are the factors that tell against the court either awarding it or reducing it?
So if I run my brain through some of the cases, it would be things like no notice was given. So they didn't have the opportunity to find somewhere else to live, or they were only going to be able to pay it if they got an equalisation of spousal maintenance.
Overwhelming contribution on the other side of the ledger, like to children or the family.
Something like that.
Because it would be offset.
Yes.
No income, basically.
If the person who moves
a
out,
trust.
if the person who moves out isn't paying,
It's a trust property. A trust property. Yeah.
Well, that brings me to question 13. Does the same thing apply when the family home is owned in a trust?
So this is a bit more tricky. A few legal hurdles here or not. So first of all, we've got a Supreme Court decision that says no, there's no jurisdiction, so you're out. And
What was
then
that Supreme Court decision?
that was something, and
Wasn't
is it
Clayton?
PAX?
that's
Let's see if
right.
I've got that.
We'll edit that out. Do you want to give that answer?
No,
again?
I can find that for you. I have no problem. Simpson and Sachs. And the court in that case, and since you're going to ask me, it's probably right here. Sort of had a list of things, but basically at the end of the day said that there's no occupational rent claims. So what we've seen a little bit of is that if your substantive claim is maybe a 44 or 44C or some provision where you're trying to back the property out of a trust and into back into the relationship property pool, then you'll get your claim. So don't think just because it's in a trust that you don't want to give notice and you run into that
and it's the
scenario.
reason that you can't, that generally is not occupational rent, you can't charge it on a trust property because the trustees are usually the two parties, and trustees would need to be unanimous, because I think there was a case that said the trustees are the ones who decide if somebody should be paying rent or not.
Yeah, so in this Sachs, Simpson and Sachs, I feel like it had an initial name after that, the court said payment of occupational rent is based on the understanding that the co-owners of property are the trustees to each other of the other's beneficial interest in the property. And a trust cannot claim occupational rent from a discretionary beneficiary where it has allowed the discretionary beneficiary to have free use of the property and has not revoked the permission. And then there are a few other things in that decision.
So usually that's how it's set up in the initial stages, right? The trust owns the house and the beneficiaries can live in it as long as they pay the outgoings. And so if they haven't made a decision to change that can carry on.
And trustees need to be unanimous, so you're generally not.
Depending on what the trustee said, but yes, more often than not. One thing that was interesting in here was that they did say that most in New Zealand, most of our trusts are discretionary family trusts, but say you have a fixed trust, then you can bring a claim against the other beneficiaries for occupational rent. So that was quite interesting.
Not too many of those though.
Okay.
But so just take that a step further. We don't have an answer on this yet, but Jenny Hawker in our office has just run a case where she sought occupational rent on a trust home, but a brainstorming got in through section through Rule 141. So that's now our provision to get Trust Act decisions into the family court. And there's two ways that you can do it. You do it by consent, which this wasn't, so she used the other avenue. And then what she said to the court is that the decision that the trustee made, because you make your application under 126, the decision that they made wasn't reasonably open to them at the time, etc., etc. Look at those provisions, 141, Section 126 of the Trust Act, and then 127 allows the court to make a determination about that.
What about 182? of the Family Proceedings Act
Proceedings Act.
if they were married.
Hang on, so one step further.
Yeah.
So that case then, she said that would then allow the judge to, under Section 182, exercise their discretion as they saw fit.
So now we're at the quickfire question part. Amanda hasn't seen these questions before, so very unfair of us to be setting a timer.
Is occupation rent an automatic right when one party stays in the home after separation?
A legislative right, but not automatic, no.
Does it affect occupation rent if one party is paying and the other party is doing more of the child-related work?
All taken into consideration, because even if somebody's doing more of the child-related work, but and they're in the home and they have a good income, there might be circumstances, super fact specific for each family.
Awesome.
The question is, should lawyers face a selection process like doctors to ensure they have the EQ for the job? You can deal with all lawyers or just family lawyers? It might be different answers.
Oh, that's hilarious. It's like some sort of EQ psych testing.
Doctors have to do it, bedside manner, empathy.
Right, yeah, they do.
All lawyers?
I think all lawyer for child lawyers should.
Yeah, well, they're self-selecting for the nice ones.
Yeah, and do you know what? Even if it wasn't a legislative requirement, do it for yourself. See where you fit.
Awesome. Are you a telephone, email, or letters lawyer?
So I still dictate because I can still talk faster than I can write. But anything difficult, I like to pick up the phone because I just think I can't use my intuition, coming back to the start, if I can't talk to people. And then you just get a feel for what's not there. I think there's a lot of benefit in a phone call, and I think there's probably not enough of that.
What's your strategy for dealing with work stress?
Oh, I'm quite a good shut-offy person.
Technical term.
Yeah, a very technical term.
Shutty-offy.
I like to. Do you know what? If you go straight to my family, my kids are amazing, but they're teenagers still, and they're a lot of talking. I do a sauna, love the sauna, that's really good. At the end of the day, I'll call someone and say, can you turn it on? I'll be home in an hour, and by the time I get home, I'll just have 25 minutes in there by myself, quietly, and then you come out sort of having purged the day. I try to have a really careful balance of COCA cases to property cases because those high-moving, high-stress COCA cases become too much, and I will only usually, at the moment I've got two, but I would only usually run one lawyer for child case at a time because those ones actually, out of all these complicated relationship property cases, they're my most angst. Is making sure that the welfare and interest that I'm considering for these children is the right decision. So balancing my caseload, it's impossible because I'm a yes person, I find it very hard to say no to things, so I'm working on that.
Cool. What is your top tip for lawyers starting out? A 10-second top tip.
Don't feel as though you have to be pigeonholed into the first thing you do. Because if actually you can get in somewhere and you start doing property, or you're doing wills and estate work, or you're doing commercial work, if ultimately you end up wanting to be a family lawyer, none of those skills are wasted. Because I always say, especially with respect to relationship property, you have to know everything. You need to know trust law, commercial law. You're not in a deep dive, but enough to know what you don't know and who to speak to and what to do. Accounting, also not wasted. You get a lot of young lawyers who've got accounting and legal background.
And old lawyers too.
Just keep your horizons open and don't think you need to be pigeonholed in it. And sometimes you need to go a little bit backwards to go forward. If you later decide, oh, actually I would have liked to get into family law relationship property, take the step backwards to go forward. It'll be worth it.
What is your top tip for someone who is recently separated?
Breathe. Find a good support person who's non-judgmental in your immediate community, because
by the hour.
Because you'll flip-flop all the time. One day you'll be like this and the next day you'll be like that, and somebody who's not going to tie you to those previous decisions, because you're allowed to change your mind 100 times through that process, And not every lawyer is the right fit for someone. It's a bit like going to see a counsellor or a psychologist. You might go, oh, not quite right. Don't feel like you can't move. We're not precious. We know sometimes that you might need someone more expensive or cheaper or more empathetic or a male or a female. It's just, take your time on that. Yeah.
Cool. What is the worst thing to do when you separate?
Make any big decisions, because your brain is already in a state of fight or flight, and going and making a too big a decision, I'm going to move here, or I'm going to quit my job, or I'm going to, get a boob job, or whatever, just anything that's too dramatic physically or mentally, just pause and say, that might be a good idea. Do I trust my decisions right now? I mean, everybody in the moment is not going around going, right, I'm going to do this decision and it's a bad decision. No. You're only trying to make the best decisions you can at any given moment. But in hindsight, when you're not in that fight or flight mode, you might go, actually, I don't want to do that anymore.
That's one of the exceptions to when you should use your intuition, right?
Yeah.
Is when you're in a high stress situation, because you're getting messages from all over the place and it's not necessarily your intuition.
Oh, I know, the hairdresser and the taxi drivers, they know everything, often, so it's take it all on board, use that trusted confidant that you've got, or few people, to sound them out. Some people are really keen to make decisions for you. They're being helpful, they don't mean to, but be aware of those people and say, hang on, is that your decision for me? Is that my decision for me? And just take your time through that process. You can find people to help you think quick and slow. That's sort of what you're trying to do often, isn't it? Is think quick and slow when you're in that heightened state.
You need different people to serve different purposes.
Absolutely.
Your family to talk to. You maybe need someone who's not going to get sick of you talking to them, and you might have to pay them, like a counsellor, someone to work out your things
work through,
on. And then when you talk to your lawyer, you're not paying for a counselling session, I suppose, as awful as that sounds. So we reached the part of the podcast where we ask the best question ever. And for Amanda Donovan, that question is, what has been your hardest case ever? Why was it hard, and how did you get through it?
That's a hard question. It's a mean question.
It's a good one for other lawyers.
Just revisit the PTSD around those cases. My hardest case ever was a relationship property case, trust case. Very few legal avenues to follow, so lots of dead ends. People want results, but there aren't any. I had a very difficult client in that case, and I had a very difficult counsel on the other side in that case. Yeah, so what made that difficult probably were the legal issues and the people. And so that was one where we had to get through. You're thinking all the time, what's your way through? And the way through for that one is that they need to be in a room. The legal avenues weren't great, so really be in a room, because then you can work out what the issues are. The issue's not the issue. And then how I managed it personally wasn't great. It did cause a bit of anxiety. But I had a senior legal counsel that I would talk to and say, am I going mad? And that often
sharing
helps.
The burden a bit.
Having a team environment helps, because everybody talks about the things that are hard and the things that are funny, and that sort of keep it light if you can, because it's a tough job if you take it all home with you all the time. You just have to be able to put these things into their little respective boxes from time to time. And so there's not many cases that I would say, that kept me up at night, but it was mostly because I'd get an email at 5:15 from the lawyer on the other side that was just horrific and was never going to be conducive. Now, maybe based on their instructions, of course, but I still think that there was lots of that was unnecessarily aggressive.
And that makes it tricky. When we talk to clients and we'll say, it's really good, they've got a really good lawyer on the other side, and your client's initial reaction is, oh no, there's a good lawyer on the other side. But it's actually a good
It's
thing
really
if you've
good,
got
yeah.
two good lawyers that are wanting to resolve it and know what they're doing, you end up with a better result for everyone.
Yeah, absolutely.
Yeah.
Which ties you back into the start where I talked about Tony Lendrum's mediation slot with you guys, and allowing people that environment to be able to have their moment to say the things that they probably wouldn't get to in court. In the same way, allows a bit of a clear the air, and if you can clear the air, you can get on, right?
Actually, Gay Greenwood in our FDR episode, she talks about the same thing. Lawyers, in her own personal case. Then the two of them got in, they were like, could the lawyers leave the room for a minute? And then they worked out a solution. And obviously the lawyers were a big part of it as well. But anyway.
Well, that's rare, but anyway.
Well, she is a mediator,
Yeah.
I guess, and same with Tony. Awesome. Okay, so that's been Divorce Cafe. Thank you so much to our special guest, Amanda Donovan at Haigh Lyon. So many great insights into both occupation rent and Section 18B, and being a lawyer and how you survive it. And being a client and how you survive that. If you'd like more information on this topic, there'll be links in the show notes, and we hope that you join us again for Divorce Cafe. Thank you, Shelley.
Thank
I
you.
never thank you, do I? Thank you so much. All right.